Hello everyone, my name is Sonam Narayan and I'm currently pursuing BA LLB from University of Petroleum and Energy Studies. I'm in my fourth year and I'm interning under LEXIS and COMPANY. Today in this video, I will be talking about the mutual divorce. Now, mutual divorce is filed when the both parties want to or mutually agrees for the divorce. So basically, when a husband and a wife both wants a divorce, then they can file for the mutual divorce. Divorce by the mutual consent or mutual divorce is when both husband and wife mutually agree that they cannot live together anymore and that the best solution uh, for that marriage is to get divorced. They would present a mutual divorce petition jointly before the honorable court without putting forth any allegations against each other. Now, the section 13B defines the divorce by mutual consent or talks about the divorce by mutual consent. Section 13B of the Hindu Marriage Act says that a petition for dissolution of marriage by a decree of divorce can be presented to the district court by both the parties to a marriage together. Now, whether that marriage was solemnized before the Marriage Laws Act 1976 or after the commencement of the Marriage Law Act 1976. So the year, the divorce, the marriages which happened before the enactment of the act, as well as after the enactment of that, both are eligible to file a petition under this section. All right. Moving further, on which ground these petition can be filed? On the ground that they have been living separately for a period of 1 year or more, that they have not been able to live together, and they have mutually agreed that the marriage should be dissolved. On this ground, they can file a petition in the district court that they want their marriage to end by the divorce, and they want a divorce by the mutual consent. Now, on the motion of both the parties made not earlier than 6 months after the date of the presentation of the petition, referred to in subsection 1 of the section 13B of the Hindu Marriage Act, and not later than 18 months after the said date, if the petition is not withdrawn in the meantime, the court shall, on being satisfied and after hearing the parties and after making such inquiry as it thinks fit, that a marriage has been solemnized and that the averments in the petition are true, pass a decree of divorce declaring the marriage to be dissolved with the effect from the time of the decree. Now, let's talk about the period of 6 to 18 months provided in section 13B. What is it? So it is a period of interregnum which is intended to give time and opportunity to the parties to reflect on their move. It is just a time given to both the parties that what do they really want, to ponder upon it, or if they want reconciliation, they can do so in that period, and for that purpose only, to sort out their matters or to just give them some space and time. This period is given to them. So in this transitional period, the parties or either of them may have second thoughts. That's why this period is given, and this period is very beneficial also. In some of the cases, it was seen that it really worked, and therefore this period of 6 to 18 months is being given to the parties who want a mutual divorce. Now, the period of living separately for 1 year must be immediately preceding the presentation of petition. All right. So it cannot be like, for example, if a couple in 2010 lived separated, and in 2011 and 2012 they were together, and in 2013 in 2012 only they go and file a petition that now they want a divorce by the mutual consent, and they have lived separated in the year of the 2010. So in that case, that 1 year won't be counting as the as the year of the separation. As to file the petition under this section, the period of living separately for 1 year must be immediately preceding the presentation of the petition. So if a person is filing a case in the year, suppose 1st of April 2012, so for the period of 1st of April 2011 to to the time when the petition was filed, the the preceding period of that separation of 1 year must be immediately uh, before the immediately before the time period when the presentation is being filed under the district court. Now, here, the expression living separately connotes not living like husband and wife. All right, it has no reference to the place of living. The parties may live under the same roof and yet they may not be living as husband and wife. So, in the case of the Suresh Devi versus Om Prakash, it was held and stated that the parties should have no desire to perform marital obligation. Then also it comes under the provision of this living separately only. Now, the period of 6 to 18 months time is given in divorce by mutual consent as to give time and opportunity to the parties to reflect on their move and seek advice from relation and friends. Now, mutual consent should continue till the divorce decree is passed. The court should be satisfied about the bona fides and consent of the parties. If there is no consent at the time of the inquiry, the court gets no jurisdiction to make a decree for the power. If there is no consent at the time of the inquiry, the court gets no jurisdiction to make a decree for divorce. Now, if the court is held to have the power to make a decree solely based on the initial petition, it negates the whole idea of mutuality. Now, there can be unilateral withdrawal of consent. All right. So, in the case of Suresh Devi versus Om Prakash, it was held that since consent of the wife was obtained by fraud and wife was not willing to consent, there could be unilateral withdrawal of consent. So, the court will ensure that both the parties have filed the petition in a bona fide manner, in a good faith, and both of them are really willing to have the divorce. All right. Now, we will see what are the steps and how we file a petition for the divorce and the mutual divorce is being obtained. So, the first step is that you need to file a petition to file for a divorce. There are certain papers which will be required to file along with the petition, such as your birth details and family details, details of your income, details of the asset owned, income tax returns filed for a period of 3 years. Now, how do we decide here the jurisdiction of the court? So there can be in a three jurisdiction you can file your case. Where the couple was living when they were living together, where did they live together, and that place, and in that place the court they have the jurisdiction to file a petition. Second, where their marriage was solemnized, and thirdly, where wife is residing at present. After doing all that, we move to the step 2, which is now there has to be appearance before the court and there will be the inspection of the petition. Here, the family court will try to convince the parties to drop off the idea of the divorce, and then also if the parties are reluctant enough that they really want a divorce and they are not ready to adjust, then the case of the proceedings will go on. Now we come to the step 3 then, which states that the passing orders for a recordment of statements on oath. All right. After that, the step 4 comes into the picture, where the first motion is passed and a period of 6 months is given before the second motion. We saw the provision of this 6 month in the section 13B of the Hindu marriage. After the step 4, we move to the step 5, where the second motion and the final hearing of the petition is being done. Now, as we saw in the step 4, that there was a period of 6 months which was given to the couple, and we saw that provision in the section 13B as well. Now, here one important thing or one important issue which arises is that the period of the 6 months can be waived off or not in, because this is a mutual consent for the divorce. Then why are we getting the 6 months period? So there the the 6 months can be waived off if there is no dispute on the issue of alimony, custody of the child, or if the court is of the view that the waiting period will only extend the adversity of the parties. In that cases, this 6 month period has been waived off. Now, after this, when the court believes that there is no scope for the reconciliation and the facts and the statements given by the parties during the time of the proceedings are true and are not misleading, then we move to the sixth step and the final step, where the final decree of divorce is pronounced. All right. So, in the case of the Grandhi Venkata Chitti Abal and Dinesh Kumar Shukla versus Nita, it was held that the waiting period of 6 months are compulsory. Otherwise, the essence of the section 13b clause 2 will be violated. So it is very necessary that this period must be given to the couple. Whereas in the case of the Hitesh Narendra Doshi versus Jaisal Hitesh Josh, it was held that the period of 6 months is necessary and cannot be reduced. All right. Um, but uh, in the case of Grandhi Venkatachitiyabal and Dinesh Kumar Shukla versus Nita, it was also held and stated that the period can be reduced from 6 months on the discretion of the court. So if the court feels right that given the 6 months will only complicate the matter and waste the time of the parties or on some other grounds, then it can reduce or waive off that period. Thank you very much.